Good morning, everybody. Thank you for dialing in today. We have got quite a number of people who have signed up for this webinar, so I'm just going to wait a couple of moments just to allow everybody to join and get comfortable before we begin. So if you just bear with us just for a moment or two whilst everybody gets logged in. That's great. We've got quite a few people joining already. So I'll make a little start on the introduction. So good morning, everybody. My name's Faye Stenning. I'm a marketing manager here at InfoTrack. I'd like to welcome you to today's webinar, where we're going to hear about the protection for transactions being set aside under the Insolvency Act of 1986. So taking you through today's webinar, I'm delighted to be by Steve Johnson, who's a Business Development Director at CLS Property Insights. Just before we begin the webinar, I'd like you to draw your attention, please, to the Q&A tab, which you'll see at the bottom of your screen. We will be running a Q&A session at the end of this webinar. So if you do have any questions, please type them into the Q&A box along with your name for Steve. And that way, if we run out of time, or as may well happen, your question requires further clarification, we can extract your information and follow up with you directly after the webinar. So I think we've got quite a number of people who have joined now. So without further ado, I'd like to hand you over to Steve, who's going to take you through this morning's webinar. Thank you, Steve.
Excellent. Thanks very much, Faye. And hello, everyone. Welcome to the webinar. My thanks for you for joining us. As Faye said, this is the Bankruptcy and Liquidation Protection for Transactions being set aside under the Insolvency Act guide for conveyancing firms. For those of you that don't know, CLS have worked for many years now with InfoTrack. We're very pleased to offer our webinars via the InfoTrack platform. And my thanks, as always, to Faye and her team for pulling this webinar together and for promoting it to InfoTrack clients and other contacts that they have. As you'll see from the agenda, it's quite extensive today. We'll be looking at the risk posed by the Insolvency Act of 1986. We'll be looking at key terminology, bankruptcy and insolvency, liquidation versus administration. We'll be looking at the types of transactions and what is caught by the Act, and a very common factor in conveyancing, the bank of mum and dad. A little bit of context around levels of insolvency that we see across the UK, and some tactics as to quantifying the risk posed by a particular transaction. We'll also be looking a little bit of detail at the CLS Insolvency Act Policies that are available through the InfoTrack platform. And we've got 3 claims case studies, which we'll touch on at the end of the presentation. So I hope a useful agenda for all of you. Just to echo what Faye said on the introduction, please do post any questions you have into the chat. Do include your names, because some of the questions that come in, we found this on previous webinars, the technical nature of those questions means sometimes we refer them back sort of certainty to one or two of the matter experts we have sitting behind, be the underwriters or whoever it may be. And then once we have that sort of expert comment, we'll then feed the answers back to Faye and team. We'll distribute them out to everyone who's attended, but particularly obviously to those who originally asked the question. So what is the Insolvency Act? So we're talking about protection for transaction risk of potentially being set aside under the Insolvency Act, but what is the actual risk here? Well, the Insolvency Act gives liquidators the powers to investigate any party who has gone into either liquidation or bankruptcy, and they will investigate their previous transaction history and endeavour to get the maximum repayment of debt for the benefit of creditors. So, if within the relevant time, 5 years for a transaction at an undervalue, 2 years for a preference transaction, and 6 months for preference, which is not a transaction at undervalue, there has been a deed of gift, cash gift, or a transaction at an undervalue, then the trustee of the bankrupt estate may apply to the court for an order under the 1986 Act. The court can then restore the position to what it would have been for the creditors if the individual had not entered into the gift or the transaction at an undervalue. So basically, they can overturn the gift or the transaction itself. This is designed to protect creditors from bankrupts who either deliberately or willfully give away cash assets or sell property for less than it is worth in order to escape their creditors from claiming it, repay the debts owed to them. And in order to understand when this might apply, we need to understand some of the key terminology used in these situations. Bankruptcy and insolvency may appear to be interchangeable terms, but they are actually different. Bankruptcy is the legal process when a person can no longer pay off their debts and has been declared insolvent. A bankruptcy petition can either be filed by the bankrupt or a creditor can file for bankruptcy if they are owed £5,000 or more. The court will then order that the individual is made bankrupt and allow the bankrupt to seek relief from some or all of their debts. Once a bankruptcy order has been made, the order will last around 12 months. At the end of that period, any debt is written off unless any property was gifted or transferred at an undervalue in the previous 5 years prior to the petition, aimed at defeating the claims of the creditors. However, bankruptcy does not apply to limited companies or to partnerships. And insolvency is where a company or individual is unable to pay their debts on time. Insolvency proceedings occur after less formal arrangements of improving the financial situation have failed, such as an individual voluntary arrangement. This is at the point when an individual or business can no longer pay their debts when they are due. Now, following on from this, let's take a look at liquidation versus administration. Although these are both formal insolvency procedures governed by the 1986 Insolvency Act, they both achieve very different outcomes. Liquidation is the process of terminating a company by either selling or liquidating its assets before dissolving it entirely. This course of action is taken when a company is beyond rescue or when its directors no longer want to continue running the company. Administration is the process used when there is a chance of saving a business, which is currently experiencing high levels of financial or operational distress, and is used to try and prevent the company from entering into liquidation in the first place. Now, we also need to take a look at the Act itself and the relevant sections within it. In particular, sections 339 to 342 of the Act, transfers by an individual, and section 238 of the Act, transfers by a company. Where the company has at a relevant time entered into a transaction with any person at an undervalue, the administrator may apply to the court for an order under section 238. Section 339, transactions at an undervalue. This section applies when an individual is made bankrupt and he or she has at a relevant time entered into a transaction with any person at an undervalue. Section 340, preference. This section applies where an individual is made bankrupt and he or she has at a relevant time given a preference to any person. Section 341, relevant time. Relevant time under section 339 and 340 are defined as time at which an individual enters into a transaction at an undervalue or gives a preference subject to 5 years for a transaction at undervalue, 2 years for preference, 6 months for preference, not a transaction at an undervalue. Section 342 orders relates to an order under either of these sections with respect to a transaction or preference entered into or given by an individual who is subsequently made bankrupt. So what types of transactions are we actually talking about that could be set aside under the Act? Well, as per the relevant sections of the Act just discussed, the transactions we are looking at are: 1, a deed of gift or gifted deposit, which is relatively common between family members and is being used more often than not by children of the gifting party to assist them in taking their first steps onto the property ladder. 2, a transfer at an undervalue, which is where the property is being sold for less than its true value. This is common for sellers who wish to sell quickly and is sometimes used as a bargaining tool for cash buyers who tend to be able to complete much more quickly than other buyers in the chain. This can also be used in the event of adding or removing a husband or wife from a mortgage deed. 3, company transactions at an undervalue. In this case, in order for the court to undo the transaction, the office must prove that the asset was sold for less than its true value, and that the company was unable to pay its debts at the time of the transaction, or that the asset was sold for less than its value, and the company became insolvent as a result of the transaction. 4, transfers and or gifts by a company. As an example, this could be where a company is selling an office premises to an individual for it to be converted for residential purposes. So by looking at this a bit more closely as to what type of transactions might be caught by the Act and what is actually a gifted deposit. The first type of gifted deposit is a seller's gifted deposit. And this is where the seller gives part of the purchase price to the buyers as a discount in the property price or as a deposit in the sale contract. This could either be by the seller, such as the house builder, reducing or waiving any actual deposit payable by the buyers on exchange of contracts. Or it could be the seller contributing or refunding part of the purchase price paid on completion, or both. In practice, a seller's gifted deposit is really just a reduction in the price. And the other type of gifted deposit is a family gifted deposit. And this is where the buyers of a property are given some of the purchase price by someone else, usually a member of their own family. For example, one or both of the buyer's parents may give the buyers either all or part of the deposit due on an exchange of contracts. So we will refer from now on to the person or persons giving the gifted deposit as the giftors. This could also be by way of a deed of gift between family members, where the whole property is gifted, either by inheritance or by as part of a divorce settlement, or just through love and affection. And the third type of transfer and gift by companies, the third type is transfers and gifts by companies. So this could be the sale or transfer of a property within companies at an undervalue. And transactions will only be risk of being caught if the act by the act, if it is a true gift. So the key consideration here is it actually a true gift, i.e. it must be a true gift and not a loan. If the money is repayable at any time, or if there is any interest applied to it, then it isn't a gifted deposit, but it's really just a loan and won't be at risk under the Act. That said, lenders will generally not be prepared to accept the gift or having any second mortgage or charge registered against the property anyway. They will want a letter confirming in writing from the giftor that it is a non-repayable gift, and specifically that it is not repayable on the sale of the property or at any other time. The giftor must also have no rights in the property. If the giftor expects to get the money back at any time, for example, on the sale of the property or by way of a percentage of the sale price when the property is sold, or if the buyer's relationship breaks down, then this isn't really a gifted deposit situation either. It might instead be a trust situation, but we're not discussing that here today. Lenders again will generally not be prepared to accept the giftor having a mortgage or charge to protect the giftor's alleged share of the property, or there being a trustee saying that buyers hold the property on trust for them and the giftor. And then in addition, the giftor must have no control over the property. Also, the giftor will have to accept that they have no control over the property whatsoever, and this includes no right to say who visits or resides at the property, when it is sold, how much it is sold for, or who it is sold to, or what works are carried out on the property, and that they themselves have no right to visit, stay, or reside there either. And in fact, they cannot use the property or address for any purpose at all. There should be no conditions whatsoever attached to the gift. Having looked at the timescales already, we've already established that if the giftor was insolvent at the time of the gift or goes bankrupt within 5 years, then there was a possibility under the Insolvency Act that the trustee in bankruptcy might try and reclaim the gift on behalf of the creditors. Therefore, you may wish to obtain or consider obtaining an Insolvency Act indemnity policy to cover this risk. You should also always carry out a bankruptcy search against the giftor before completion. A declaration of solvency from the giftor will also usually be required, and it will usually be a condition of any lender. The giftor signs a gifted deposit letter to confirm that the gifted deposit is a pure gift and not repayable under any circumstances just discussed. So how common are these types of scenarios in practice? Well, in 2021, the Bank of Mum and Dad supported 49% of first-time buyer purchases. Total contributions from parents helping younger generations to buy a home are expected to reach 9.8 billion by the end of 2021, according to analysis from property group Savills. This equates to an average of just over £58,000 in gift or loans for each supported house purchase. So it's quite likely that you will come across these types of scenarios in your day-to-day conveyancing work. We've also already discussed that the risk arises when the person that gave the gift is declared bankrupt, and looking at the most recent insolvency figures from the UK government website, we can see that the number of registered companies in company insolvencies in October 21 was 1,405, 63% higher than the number registered in the same month the previous year, 864 in October, but 5% lower than the number registered 2 years previously, pre-pandemic, 1,480 in October 2019. And of course, insolvency figures have been significantly thrown out by the pandemic, the furlough scheme. There was actually, one wants to use perhaps a sort of a harsh phrase against insolvencies, fewer insolvencies taking place than one would have expected, due in part to government support that existed during the depths of the pandemic. To some extent, there's a return to the norm presently arriving, although obviously the cost of living crisis is undoubtedly going to have an unpleasant influence on numbers going forward. For individuals, 601 bankruptcies were registered, which was 44% lower than October 2020 and 57% lower than October 2019. There were on average 7,031 IVAs registered per month in the 3-month period ending October 21, which is 40% higher than the 3-month period ending 2020 and 4% higher than the 3-month period ending 2019. So, in order to quantify the risk when looking at a specific transaction, you may wish to ask yourself some of the following questions. Are any discounts or incentives being offered to offset the deposit? Is any cash being gifted by a relative? Is a transfer between family members or part of is there a transfer between family members or as part of a divorce settlement? Is there any difference between the open market value and the price being paid? And have there been any previous sales at an undervalue within the past 5 years? Or indeed, are any company assets being sold off to an individual or transferred between group companies for potentially less than their true value? Now, at this point in the presentation, we will go towards the claims case study. But prior to doing that, we'll just spend a little bit of time looking at the type of insurance that's available to protect either the lender, buyer, and to some extent, of course, yourselves as conveyancers as well. And I hasten to add, for context, one never claims that insurance is the sole way to resolve a particular conveyancing issue, but it is an option in certain circumstances. And we hope that the policies that are outlined in the following slides have the potential to provide sort of comfort to yourself and, of course, to the clients that you're representing. So what is Insolvency Act 1986 legal indemnity insurance? What policies are available from CLS? In essence, there are two main types of Insolvency Act legal indemnity insurance policy. You have Insolvency Act current transaction legal indemnity insurance and Insolvency Act previous transaction legal indemnity insurance. Either type of legal indemnity policy can cover property transactions at an undervalue, gifts of property, current or previous transactions where the sale at an undervalue or gift is by an individual or co-owners, and current or previous transactions where the sale at an undervalue or gift by a limited company. With regard to the current transaction insolvency legal indemnity, There are many genuine and reasonable reasons why a property owner may be selling their current property at an undervalue, some of which we've already discussed. For example, the sale or gift of a family house by a parent to an adult child or other family member, the sale of a property that is a probate sale, where the executors and the beneficiaries are keen to achieve closure because of the cost and inconvenience of maintaining an empty property. The sale of a property where the owner has had a windfall, for example, they won the lottery or received an inheritance, and the property owner therefore wants to move on with their life. Or the transfer of a property to a former husband, wife, or civil partner as part of a divorce, financial settlement, or separation agreement. The CLS Insolvency Act Current Transaction and Insolvency Act Previous Transaction Policies provide cover should a transfer at undervalue or by way of a gift of the property be set aside because of matters contained in section 339 to 342, transfer by an individual, or 238 of the Insolvency Act 1986, transfer by a company. Clarify what cover is provided. Purchaser cover can only be obtained where there is no relationship between the insured and the party who gifted, donor, transferred as the transferor, the property at an undervalue. If there is a relationship between them, we would offer lender cover only. The rationale here is that if the bankruptcy was pending, the relative would likely know about it. While purchaser cover generally stems from where there is an arm's length transaction, there is an exception to this rule, and we can look to offer cover offline for a cash buyer. Cash buyers commonly push to reduce the purchase price as they can be seen as more desirable purchasers on the basis that there is no chain, and as such, we feel more confident that there is no collusion as there is a benefit of the property selling for less. So, looking at these policies in a little more detail, where cover is required where the current transaction is at an undervalue or deed of gift. The Insolvency Act Current Transaction covers the lender only where the property is currently transferred by way of deed of gift, or the property is currently being transferred for less than its true value, or part of the purchase price, usually by a gifted deposit, being provided by someone other than the buyer, or finally, the registered name of the property is being changed from one name to another for nil consideration, most commonly through a divorce. And the policy goes on to protect the lender's interest should the property be set aside under the relevant sections of the Insolvency Act 1986. Now, in relation to where cover is required for a previous transaction that was at an undervalue or deed of gift, the Insolvency Act Previous Transaction Policy covers a mortgagee and purchaser for an arm's length transaction where the property was previously passed by a deed of gift, or the property was transferred at less than its true value, or part of the purchase price, usually by gifted deposit, was provided by someone other than the buyer. Now, as you'll see popping up on screen here, all of the policies, of course, are subject to agreed statements. And I'll not go through each and every one of those on screen, but these slides will be coming round to you afterwards, so you'll have a copy of these to refer back to. What I should say here is that InfoTrack have adopted a principle that CLS provide called variable statement of fact. And this is a mechanism by which orders that are for policies which are being placed online on the InfoTrack platform can look at the statement of fact. And if they don't apply to the current transaction you're working on exactly, you have the ability to adapt the statements of fact according to a drop-down menu that the InfoTrack system provides. And what this means is you have the maximum chance of actually being able to fulfill that policy requirement online on the InfoTrack platform there and then, rather than having to drop offline and speak to an underwriter. Now, of course, the facility is still there to refer over to an underwriter, but we hope that this use of sort of clever statements of fact option technology means that when you are referred to an underwriter, it's really because there is something perhaps quite unusual about the transaction, and that sort of highly bespoke, tailored nature of the policy is needed with an underwriter's manual input. So say those of you that are already InfoTrack clients will have seen that variable statement of fact principle in operation. We hope it's meaning from an efficiency point of view, you're getting policies that are suitable for your clients there and then online. But of course, you always have as that fallback the ability to be referred across to an underwriter for a conversation to tailor a policy, particularly to unusual circumstances in conveyancing case you happen to be working on. Now, we're moving on now to the 3 claims case studies that we were going to mention. So the first scenario relates to a lender only cover on an individual transaction. So in this scenario, a parent gifts their child a sum of money towards their deposit for their first home. The child's lender requires an Insolvency Act policy to be incepted, as this is to cover the current transaction and the parties are related. Therefore, of course, a lender-only policy is obtained as noted previously. Parent later becomes bankrupt and one of their creditors claims an interest in the property as one of the bankruptee's assets. As they become aware that the parents gifted money towards the child's purchase of the property, the creditors under the rights of the Insolvency Act have the right to reverse the transaction, meaning that the deposit amount will be payable back to the creditors. In this scenario, CLS Property Insights policy would protect the lender's losses in this situation should the child default on their mortgage payments following the next steps made by the trustee in bankruptcy. Example 2, this scenario illustrates current transaction cover where the purchaser is a company. So in this scenario, a company sells a commercial office space at an undervalue to another subsidiary company, and 6 months later, they go into liquidation. As the donor company has gone into liquidation, the creditors realize that there was a transaction at an undervalue. The directors of that company would have had an obligation under the Insolvency Act of 1986 not to commit any business transaction which may be a loss to the creditor. As such, the creditor could claim under Section 238 of the Insolvency Act, unless the original donor can prove that the transaction occurred in good faith and for the purposes of carrying out their business. The CLS policy in this instance would cover any losses. Our third scenario gives an example of a claim on CLS PI's previous transaction insurance. In this example, a father sold their property at an undervalue to their son as a gesture of love and affection in March 2018. The property was sold in 2019 and again in 2021. At the time of the January 21 transaction, and as it was an arm's length transaction, an Insolvency Act previous transaction indemnity was obtained to protect both the lender and the purchaser's interest in the property should the original transferor, the father, become insolvent, meaning that the new owner may be at a financial loss if creditors attempt to reverse the original transaction to satisfy their debts. If any creditor subsequently makes a claim under the Act against the father's original transaction at the undervalue, both the new purchaser and the lender would be covered. Now, all of our policies, including the ones we've spoken about today, are of course available from the InfoTrack platform. I very much hope that today's session has been useful. Obviously, if there are any questions, Faye and Heike are very happy to look at those now. But in the meantime, my thanks again for those of you attending, and my thanks again to Faye and the team at InfoTrack for promoting this webinar. Faye and Heike, over to yourselves.
Thank you, Steve, for your presentation and your insights. So if anyone has any questions, please do send them through and we can jump straight into the Q&A part of the webinar. But otherwise, I'll give it a moment. Okay, so we don't have any questions through, but if anyone does have any questions later, you can contact us. And I would also like to say a big thank you to Steve for joining us today. I hope you all found this session helpful and informative. If you have any other questions or if you wanted to follow up on something that you've learned today, please do contact us using the following details: sales@infotrack.co.uk. Or the details on the screen for Steve. And then the phone number for sales would be 0207 186 8090, or reach out to your account manager who will be able to assist you. So this session is also being recorded and we will send you a copy so you can refer back to it. And all that's left to say is thank you so much for joining us today, and have a lovely rest of your day. Thank you.